Test, test. Test. Can I be heard? Perfect. Let us begin our session. Good afternoon, particularly distinguished judges, scholars, academicians, policymakers, and all of you to this specific session, which will be looking at judges, the environmental rule of law, and a healthy planet since 1972 Stockholm Declaration. What have we achieved? What have been the challenges? But also, wherever there's a challenge, what are the opportunities? This is what we'd like to discuss this afternoon. My name is Elizabeth Maruma Mrema. I'm the Executive Secretary of the Secretariat of the Convention on Biological Diversity, and I'm here with my co-director, Professor Patricia Kameri-Mboti. The two of us will try to hopefully moderate and not disorganize our panelists as we continue. This event is actually the first ever dialogue at the UN Global Conference among the Supreme Court justices and high-level judges from around the world. And this dialogue will focus on the opportunities for realizing the promise of the environmental rule of law and the importance of guaranteeing judicial independence and integrity after the Stockholm Declaration. But let me begin by thanking those entities which have made this event possible. The key organizers, the Global Judicial Institute on the Environment. For those who do not know this institute, Christina will talk about it later. Another organizer, the International Association of Judges, and the Asian Development Bank. And these are the key organizers supported in partnership with the United Nations Environment Program Law Division, represented here by the director, Mbote, the Convention on Biological Diversity, the Swedish Association of Judges, the European Union Forum of Judges for the Environment, the IUCN World Commission on Environmental Law, the European Bank for Reconstruction and Development, the International Council of Environmental Law, the Environmental Law Institute, and earthday.org. So all these have made this event and all of us possible and being here. In view of the time constraints, I will avoid to say anything now. If you will give us time, we will do so at the end when everybody has spoken. But rules of the game. Each speaker will have 2.5 minutes of making the intervention. I'm saying 2.5 because by the time the clock clicks 3 minutes, you will be cut off. And you know, we don't want to be disrespectful to the distinguished judges here. So there is that sign there which will say, even stop, not that you have a second. And I hope we can all respect it so that then we have opportunity for all the distinguished panelists to be able to speak and still have a moment, few minutes for intervention from the floor. So with that rule of the game, Patricia, probably you want to say something about yourself, who you are.
Good afternoon. I think Elizabeth has already introduced me. I am Patricia Kameri-Mboti, delighted to be here with you, the director of the Law Division. And we are very happy to be working with the Global Judicial Institute for the Environment and judges in building this body of law. I think the one point I'd like to make is that we are happy to be here in Stockholm with judges who are not here 50 years ago. And I want to add that the judges are the last mile in the realization of a sustainable world. We are going to have the first group of judges speaking, the distinguished speakers, and I'd just like to pass the apologies of Judge Antonio Benjamin, who was supposed to be in this first panel, but he is in another, he's a man in a lot of demand. And we know that means that judges are being heard in different spaces. He may join us when he is able to. I'd like also to thank the side event co-academic coordinators, because there's all the others, but the people who really get the thing going. And I'd like to thank Denise Antolini from the University of Hawaii, and also to thank Nicholas Briner from Louisiana State University, who has actually, with Denise, really worked hard to get this going. We will now proceed with our 5 distinguished opening speakers, all of whom are playing very key roles in supporting the engagement of judges in training, networking, and new initiatives like participating in conferences like the one we have here, and also in others that put out the message. Let's start with Justice José Igreja Matus, the Chief Justice, Court of Appeal of Porto, Portugal, and President of the International Association of Judges. Justice Matus, please tell us who you are and the role that you're playing in this very important task.
Thank you, Patricia, for your kind words. Just call me José, it's enough. Okay. We have such a short time that I write something here, not leaving room for improvisations. So I will go directly to the paper. I want to deliver a message, so hopefully it will be delivered. 1945, the Second World War ended, leaving behind a trail of devastation, violence, and death. In the following years, international community, goodwill men and women sharing such a small planet, joined forces. Never again to totalitarian regimes, human dignity must always prevail. The Universal Declaration of Human Rights was written. The United Nations started. With this same ambition, in 1953, the International Association of Judges was founded. Only 5 national associations. The values were the ones that define modern societies: rule of law, judicial independence. Fast forward, 2022. EAJ has now associations of judges from 94 countries, the biggest worldwide. Mundialization of judges, that were the words of Antoine Garapon. Global problems demand global answers. As president of the International Association of Judges, following a crucial commitment to our defining values, it became clear since my first day of mandate that environmental protection, there is no planet B, ought to be a priority. Tell me what you pay attention to, and I will tell you who you are, proclaimed Ortega y Gasset. We judges pay attention, full attention, to the protection of nature. The present moment with menaces never seen to democracy, to rule of law, even to a viable planet, resilient decisions must be taken. As Roosevelt said, the best thing you can do is the right thing. The worst thing you can do is do nothing. Regarding the International Association of Judges, we will continue to assume an unequivocal pledge to a declaration established 50 years ago here in Stockholm. Let's work together with concrete endeavors, a strategic plan, under the guidance of United Nations, a mission to accomplish. And because I know the authors, all of you, I'm really optimistic on the quality of the next chapters. We just need to start to write them. Thank you.
Thank you very much, Jose, for not having to be violently stopped and keeping to time. We will now have Thomas Clark, the General Counsel of the Asian Development Bank.
Thank you very much. It's an honor and privilege for me to be here. I'm Tom Clark, General Counsel of the Asian Development Bank. And maybe I should just start by saying, what do we do? We're a development bank. For over 50 years, we've been committed to the economic development and the elimination of poverty in the Asia-Pacific region. But what's happened recently? We've become aware that there can be no development if there's no environmental safety. There can be no wealth, no prosperity, no inclusion if we don't tackle the triple planetary crises that we're facing now. And so with that, we've come maybe late to the game compared to some of you, but we've come with a great passion. And I just want to make a few remarks in the interest of time. When we think about how to deal with the triple planetary crisis, when we think about how to promote an active response to the challenges that we face, we see the critical role of the judiciary. The judiciary basically is the bastion and the guardian of rights, of human rights, of economic rights. And we see that the judicial branch of government has a unique capacity to function as a kind of referee that sustains those rights, and that includes inclusive and sustainable development. Indeed, the courts are the institution that protects the rights and upholds the rule of environmental law. Now, why is this so critical? Because Stockholm Plus 50, if it's telling us anything, is telling us that we need to reflect on how we can make progress in tackling these crises. And these crises are not distant, concerns for the people of Asia and the Pacific. They're immediate threats, sometimes with some of our smaller island nations threatening obliteration, not within a generation, but within a decade. Now, adjudicating these crises, though, create challenges. Judges must now understand technical science and grapple with very difficult issues, the rights of emerging stakeholders, the environment, ecosystem, indeed future generations whose rights are being compromised now. Additionally, judges are being called to interpret and to apply the law to respond to unprecedented challenges. And this exercise requires resources, knowledge, and technology, and indeed new approaches to jurisprudence. But if there are all of these challenges, we could sit here and say that's really a downer, there are a lot of things to be really happy about. And I think that we've seen remarkable achievements to be happy about. These achievements give hope for the opportunities that a steadfast approach to the rule of law can afford to the people of Earth. For example, Asian courts have been very active in relying on constitutional provisions to mobilize their governments to pass or execute laws or policy on the grounds that the government's failure to do so would actually violate constitutional rights, like the right to life, environment, and dignity. All you have to do is look at the Shrestha case from Nepal, the Lagari case from Pakistan, or Bela v. Bangladesh to see a few examples of some of the extraordinarily courageous decisions. Let me just say that we as development partners can seize this opportunity by investing in judiciaries, and we hope to help along the way. Thank you.
Thank you very much, Thomas, for very pointed remarks. And I think we are seeing that judges do have partners along this journey. I'd now like to call upon Christina Voigt, the chair of the IUCN World Commission on Environmental Law, to make her comments.
Thank you so much, Patricia. And first of all, I'd like to state that it is a great honor, a great privilege for the IUCN World Commission on Environmental Law to partner with the Global Judicial Institute on the Environment and the Asian Development Bank and many others in this event. And thank you so much to the organizers for bringing us together. Well, legal norms that protect the environment and the common values that it represents are widely dispersed. We find them in thousands of domestic acts or laws. We find them in constitutions. We find them in international treaties and regional treaties and customary laws. And sometimes we don't find them at all. Courts and the judges have important roles to play in protecting the environment while ensuring justice. They are tasked with identifying the applicable norms. They are tasked with interpreting them, now often in the light of international law, international treaties like the Paris Agreement. They are tasked with giving authoritative statements on the content of those norms. And they're tasked with balancing rights and obligations and also protecting the often unheard voice of the environment. And they're tasked with holding those to account that violate the laws to protect the environment or human rights norms. And sometimes this might be a fine and very intricate balance to strike. Courts may be conservative and protect the status quo. But, as we just heard, they can also be the dynamic, creative, and courageous developers of the law and contribute to the further development of the environmental rule of law. Courts have been instrumental in bringing about progress. Think about ending racial discrimination or protecting consumer protections against lung cancer threatening cigarettes. And courts and judges are instrumental now. They're instrumental in protecting our planet, and we are currently witnessing what I call an environmental turn to courts, where young people, children, youth, elderly, NGOs rely on the judiciary to hold governments and companies accountable, for example, for the inaction on climate change or the destruction of nature. We see an increased awareness and turn to the role on power of the judiciary, of justicia, of Lady Justice. I can only assume that it is not an easy time to be a judge, but maybe it never is. Judges need to be well informed about the science. They need to be vigilant. They need to be courageous. They need to be open-minded and creative within their legal competence. And this is both a responsibility and an opportunity. And I'd like to just say a couple of words about the Global Judicial Institute on the Environment, as I was asked to do, but I see that we've been joined by Justice Antonio Benjamin, who's busily taking pictures over there. Okay. So I leave this to you, Antonio.
Okay, thank you very much, Christina. And now I'd like to call on Nicholas Robinson, who is a professor, Pace Law School, and chair emeritus of the IUCN World Commission on Environmental Law, among other things. He was here in 1972, and I was going to ask you, Nick, because I met somebody who was here in 1972 wearing the same coat he wore in 1972. So I wanted to find out from you whether you're wearing the same coat you wore in 1972. Welcome, Nick.
Well, Patricia, I was wearing a vest then, I'm wearing a vest now, so I do recycle them. But it's an honor to be here with both Elizabeth and Patricia as our co-chairs. They're two of the giants in environmental law. And also, the three institutions that I chair this panel with are true leaders, the International Association of Judges, upholding the rule of law brilliantly over the years, the ADB, which has just been wonderful in developing not just the capacity throughout Asia for sustainability and development, but also doing it with an eye toward an ordered society in the law, and the World Commission on Environmental Law, in which I grew up because I joined that commission in 1972 at the 72 Conference on the Human Environment. In 1945, environment was left out of the Charter of the United Nations because all states took it for granted, more or less. Today, we are about to have in the General Assembly of the United Nations a vote recognizing for the first time the fundamental human right to the environment. And that was left out of the Universal Declaration of Human Rights because, again, it was sort of assumed. Principle 1 of Stockholm assumes that you have the right to the environment. But as every judge and every one of us in this room knows, if there's a right, there has to be a remedy. Rights are not just, as the Secretary General said this morning, hot air. They have to have some competence to them, some benefit, some realism. And it's up to the ingenuity of the judge and the advocates before a court to help make that happen. The Judicial Institute on the Environment was a creation of the UN Environment Program. My colleague Donald Kaniaro, who is here, was with the Kenyan Foreign Ministry in 1945 and helped create UNEP. And UNEP helped with the creation of the judicial training sessions, the capacity building sessions for judges. IUCN held, Commission on Environmental Law held joint seminars around the world from Manila to London in every region with the courts in those regions to get a sense that was this needed, would it be good to have the exchanges? We held in 2002 the Global Judicial Symposium in which a commission chair predecessor of Christina and I, Dr. Parvez Hassan, one of the giants in environmental law from Pakistan, and I were resource people to engage with judges who had never met before around the world from Supreme and High Courts to decide what should be the role of judges globally. They'd been left out of the international system, which is why, in part, the International Association of Judges created itself. And so the Global Judicial Institute for the Environment is an organization of judges, by judges, for judges. It's not set up by foreign ministries. It's not set up by litigants. It is to help the judicial tradition around the world build strength and share experiences. And it's been a great honor and privilege to be part of that story. Thank you so much.
Thank you very much. Professor Robinson, I'd now like to call on Justice Antonio Hammond Benjamin of the National High Court of Brazil, who is the president of the Global Judicial Institute on the Environment, and also a chair emeritus of the IUCN World Commission on Environmental Law. You have 2 minutes, Judge.
I love taking orders from Patricia and Elizabeth. And it is really remarkable to see that we, the judges, have as co-chairs of this panel 2 of the most powerful women that I know. But 2 women that come from Africa and 2 women that are giants in terms of knowledge of environmental law. I feel very proud to be here, co-chaired by both of you. I'm also delighted to see that this is the first time, right, Nick, that judges come together with partners since we were not present in 1972, although Nick was already doing exploratory work for us in the future. We were not present in Rio de Janeiro, and then slowly we began penetrating the UN system. And Nick has already alluded to points in this journey. I'm here much more to thank all of you and the partners, and especially the International Association of Judges, the first time that the International Association of Judges joined forces with the UN, not to discuss independence and integrity of judges, that's the core mission of the association, but to discuss the protection of the foundations of life. And the other partners that are here, the World Commission on Environmental Law, ICEL, the Asian Development Bank, and all of you. Unfortunately, I have to return to my other panel. I came here much more just to take pictures, and then I was identified by the main enforcer here, not a judge, Professor Denise Antolini. So, congratulations, Patricia, Elizabeth, the panelists, but especially all my colleagues, the judges that are here, and the others that are listening and watching us virtually. This is a very important moment for us, the judges. Many thanks.
Thank you very much, Judge Benjamin, for keeping to time. I'd now like to call my co-moderator, Elizabeth, to take us through the next steps.
With the permission of the distinguished panelists, I will request that you take your seats. Then I can call the next team to join the front. Thank you. I cannot begin without recognizing the person who was the brain behind the entire program leading us today, 2022, with the Global Judicial Institute in terms of engaging judges, magistrates in environmental management issues. And that's Donald Kaniaru hiding behind somewhere there. Welcome, Donald. For those who might not know, he is or was the brain behind to what we have today, the UNEP program, working with the judges, as Nick said, by the judges, for the judges. Where he was only facilitating, creating that avenue for the judges to meet and exchange views and experiences. Thank you, Donald. So, same question. Yes, we were not here in 1972, but we are here today. Judges are being heard. Their role very important. Yes, we face challenges, but let's be positive and look at opportunities moving forward. Justice Dambusa from Supreme Court of South Africa, take us through in 2.5 minutes. Oh, and I had it here. Yeah.
Now the time starts. Thank you, my sister. I am truly honored to be part of this gathering today. And going back to the theme that you set for us, exploring opportunities for realization of the promise of environmental rule of law and its relationship to integrity and judicial independence. I think one is a function of the other. Because for us as judges to be able to realize the promise of environmental justice, we have to be truly independent in the manner that we make our decisions, in the manner that we conduct the cases that become before us. We've got to be credible, we've got to be believable. But unfortunately, these cases we decide in a restricted or in a confined environment where the dispute is already defined by parties who are at war, each side placing its version that it wants the judge to take into account and go by. And we are also confined by the rules of procedure, rules of evidence that were set a long time ago. And they were set with the understanding that judges are supposed to know everything. And at least they have the foundational knowledge to know what the dispute is about. But unfortunately, we are learning that that is not always the case. So for us to be able to be credible and be truly independent and have the necessary integrity, we need to go out and find the information that will enable us to be truly independent. And these kinds of gatherings are what enable us then to learn from each other, to be truly effective. It is a continuous effort. I don't think we will ever get to a place where we said, now we are done. So it is important, very important for us to know that we are in a continuous journey of finding the knowledge that is necessary for us to have the foundation to be able to understand and truly be effective in resolving the disputes that serve before us. Thank you, Elizabeth.
Thank you very much. And to me, the message is the judges will continue to take the flexible approach in favor of the environment. I believe we have Justice Ricardo Lorenzetti online.
Yes, I am here.
Good to see you. Yes, loud and clear.
Okay.
2.5 minutes, Justice.
Yes, a great pleasure to be with you. Thank you very much. I agree that we need independence and we need integrity, but I think we also need to change our mind because we understand that the Stockholm Declaration is very important in shaping the global environmental law. But we need to change our mind in two orders, I think. The first one is to take a systemic approach on environmental cases based on the concept of the environment as a collective good and the merging of an environmental paradigm. For example, the Argentine Supreme Court established that the environment is a collective good that belongs to the community of common use and indivisible. The approach is systemic because it does not only take into account the private or state interest, but the environment interest. It's not restricted to a specific jurisdiction, since environmental conflicts are not limited from political or jurisdictional division. As Judge Benjamin yesterday said, we are planetary judges and the environment is our subject. We need to focus on a more systemic approach. The second approach is implementation. Very often environmental law is directed at awareness, but not behavior. This type of regulation exposes the conflict, but they do not resolve it. It opens the door to the important role of the judiciary. We need to understand that our work is not finished when the courts hands down the judgment. Courts must test the effects that the decision produces. Courts can order the implementation to the administration, like the order to clean a river, or to exhort the Congress to fulfill a gap in the legal system to protect the environment. Of course, we need to respect the discretion of the executive power, but the implementation is not someone else's problem, it's our problem. This is the position of our court, the Argentine Supreme Court. And I would like to say that we need to adopt a very different approach according to the needs of our time, because we are facing a big challenge in order to avoid an environmental collapse. Thank you very much. It's a limited amount of time, and I would like to respect the other speakers' time. Thank you very much.
Thank you, Justice Ricardo, Justice of the Supreme Court of Argentina. And I think it is important, key message from there, the work of judges does not end with the judgment, but also to implementation. I would like to invite Justice Sapana Mala, Supreme Court of Nepal.
Thank you, judges, delegates, partners. It's 50 years of Stockholm Declaration. Time to celebrate the achievement, but also opportunity for us to share the challenges. Stockholm Declaration is instrumental because it has helped us to define international environmental law. It has also helped us in making law and shaping the jurisprudence through the court. As Professor Robinson said, where there is a right, there has to be remedies. At present, environmental litigations in different courts are increasing, and this has given an opportunity for the court to examine environmental matters and correct the gaps. I want to share some of the benchmark some of the courts have created. The expression of life does not refer to mere existence. Importance of human health and that human life cannot simply be sacrificed. There is no true development in the destruction of environment. Give meaning to traditional understanding of our relationship with the environment, not only in the right to nature, but right of nature and dignity of nature. But it is still a challenging task for us to define law as it exists and what law ought to be for harmonizing laws in achieving environmental justice. Stockholm Declaration has inspired the world to transform the classic democracy towards environmental democracy and to transform rule of law into environmental rule of law. But how to achieve environmental rule of law? There's also a challenge of responding to threat against independence of judiciary in sensitive cases, those environmental decisions that might have political ramification or might run against corrupt interest in the exploitation of public recourse or violation of individual and collective rights. The sad reality of the world is that the idea of environmental justice is against development still exists. Time has come that we need to communicate with the world. Development is not a project, it's a process. In many jurisdictions, judicial review is seen as an interference in executive functioning. Such confrontations are challenged to the environmental rule of law implementation. Judicialization to remedy policy failure is seen as a undermining democratic accountability. There are many more confrontation to the environmental rule of law implementation is facing. We will hear more from my brother and sister judges.
Thank you very much, Justice Mala. Clearly, with all the important role judges play, there are challenges, and the few have been eluded. Let me invite Justice Mansoor Al-Shah, Supreme Court of Pakistan. Justice.
Thank you, but allow me to stand up and say this, because I can't sit down while my planet is on fire. I need to stand up and do something about it, so sitting down is difficult for me. Let me just say, it took 50 years for the world to bring us here to this forum, and it's so important to understand what the courts do in a country. See, the courts protect the weak against the strong, the people against the executive, you see. And in the context of climate, it's the courts who've gone ahead and moved from human rights to now protecting nature. So that's very important. Dignity of nature becomes centerpiece, you see, and that's very important. The minute you start realizing in protecting nature, you protect human, you protect the planet. So that's what we're doing. I think it's a wonderful jurisprudence being produced all over the world by the judges by interpreting progressively what these rights are all about. And we're just not saying it on our own. You see, we need to understand what are we saying. The judges are talking about international environmental law. They're talking about all these conventions that you discuss and come up with these conferences, these protocols that we develop. What is all this? This is a collective human consciousness of the planet. And that's what we're promoting. We're saying this is what the planet is talking about. So all we're telling the executive, the governments of the world, as well as the legislature, that this global consciousness, which is being evolved, starting from Stockholm, even today, this needs to be promoted. This needs to be taken ahead. So we're not opposing governments. We're not opposing legislature. We're saying come together. We need to do something together. And this is the leadership we're offering. And we're bringing in human rights, which is at the heart of it all. But more importantly, we're moving away from humans. We're saying it's all about nature. It's not about us. It's not anthropocentric anymore. Let's have a nature-centric jurisprudence and nature-centric understanding of the planet. That's where we're heading. And I think the biggest threat the planet has right now is thinking that someone else has to do and save the planet. It's we. Everybody has to play a role. Thank you.
Thank you very much. Everybody has to play their role, including judges. Thank you. I invite Justice Fabien Reynaud, Counsel d'État, France.
Thank you to give me the floor. First of all, I would like to express my honor and my pleasure to be here with you and to have the opportunity to participate to this very important event here in Stockholm. I would like to say that the multiplication of the climate change cases before national courts I think is a new challenge for judges, and I think we should be aware of that. Why is that? Because we have to find the right balance between a narrow legalism approach, Christina Voigt would say a conservative approach, as she said a few minutes earlier, and the temptation of activism, because we all know that we are in a situation of emergency. But still we are judges, and we cannot overstep our role. We have to play by the rules, the procedural rules, and of course the legal rules. But I think that we have to reflect on this issue with the idea to be innovative. I think it's a main important, and to give full effect to the legal instruments that are protecting environment, especially the international instruments, and notably the Paris Agreement. And let me share one example with you of a decision taken by the Conseil d'État in a very precise case, the Grande Sainte case, in which we have a small municipality of the north of France who attacked before the Conseil d'État the refusal of the government to take additional measures to reduce the GHG emissions. And the Conseil d'État ruled in favor of the municipality by deciding that the decision by the government was not compatible with the trajectory defined to meet the objective set for 2030, and we order the government to take additional measures. And what is interesting, I think, in that case, is that we try to give full possible legal effect to the Paris Agreement, which remains the only global legal agreement at our disposal. But on the other hand, we did not decide what kind of measures should be taken, because it is up to the government and to the parliament to decide on the precise measure. And I think it's this balance that the judge always have to remind, because behind that there is a question of legitimacy, and we cannot solve everything. The judge has an important role to play. We should not be too prudent, too careful, but we cannot solve everything. Thank you.
Thank you very much, Justice. Yes, governments do sign, commit to global environmental goals, so the judiciary can play a role to remind governments of the obligations they themselves took through the judgments. Thank you very much. I invite now Justice Joe Williams, Supreme Court of New Zealand. With our apologies, I understand it's very early for you, but I believe you are still awake to share a few words. Thank you. Justice Williams, the floor is yours.
Thank you, Elizabeth. Yes, it's 2:30 in the morning here in the bottom of the South Pacific, and I'm wondering why I ever agreed to do this.
Sign of commitment, thank you.
Or madness. Of course, as with all of my colleagues, it's an honor to have been invited to join this fascinating discussion. The focus is challenges and opportunities, and I thought I have maybe 3 or 4 points to make. First, and this sounds a little weird, but what is law? Law is inherent in our nature. It's necessary to the survival of this most social of species. It's necessary to our social cohesion and to our cohesion with place. So law has always had an environmental component, and by law I mean law across the millennia, because no community can survive without it. The problem we have is, I think, that the post-Enlightenment law under which most of us operate has really let us down. And we have discovered over the last 50 years that it's really not fit for purpose. So I've been really struck by this idea of environmental rule of law. There's a lot of meaning pushed into those 3 words. Not the rule of self or sector interests, not the rule of now or the needs of now, but law at a remove designed to think of consequences over the longer term, something that controls our most selfish instincts, and something that's, we would hope, driven by a deep understanding of context and system. So now we face, as everyone has said, this unprecedented existential threat to our existence and that of the species that we travel on this planet with. And law is our one last remaining hope. So the role of the judge becomes crucial, but not the role of the hero judge, who is dangerous, but the role of humble judges who understand we are a small part of a whole. The role of humble judges who understand we do not understand everything, yet the role of judges with imagination. Perhaps our law will develop in a way that comes to understand that nature is not separate from us, but that we are nature. The challenges we confront will test our very conception of the role of a judge and of judge-made law. The idea of property rights when the property is dissolving into the ocean, the idea of torts and climate change litigation, the place of equity and fiduciary obligations, the challenge of making legislation designed for a different reality work, the challenge of making treaties speak in local places, and to do all of that without ourselves legislating. The challenge, ultimately, over the next generation, I feel, of shifting from a conception of law centered on humans to the conception of law centered on planet with the humans as ancillary. That's the challenge. Thank you.
Thank you very much, Justice William. Indeed, we are nature, and nature is us, and the judges have a role to play on that nexus. Our panelists remain where you are as I invite, no, don't leave, as I invite my co-moderator to continue.
Thank you very much, Elizabeth, and the judges for a very heated and spirited discussion of environmental issues. We are going to now have a discussion by the judges. We will start with the ones that have been last, and then we will go to the ones that came first. We would want you to engage with each other's ideas or to add something that probably you were not able to add as we went through the time. And I think it is important because Tokmasan probably hasn't had this concentration of judges in one time. So let us hear the judges talk, and also the partners with the judges talk. And I'd like to begin, I want to begin with Justice Joe Williams, so that if he should decide to go away, we are very sorry that we kept you so late. But let's start with you. You can add what you didn't manage to say, or comment on what the other judges said. Judge Williams, are you with us?
Sorry, yes, I am. I'm awake. I set my alarm.
Okay.
I was struck by the comment by Fabian, is it? Yes, about judges staying in their lane. And I think that is that's very important. There is a question about the legitimacy of judicial action, and the environmental rule of law is just that, the environmental rule of law, and we must comply with the law bit of that, or we lose our own legitimacy. So there is this incredible yoga required to be performed by us, whereby we are adapting, evolving, and growing the law and legal categories and concepts to meet the challenges, yet still staying in our lane. I'm not sure we have the imagination and the intelligence to do that, but that's the challenge of the next generation. And I look forward to seeing how some of you figure out how to do that.
Thank you.
Thank you very much, Judge Williams. Judges in their lanes, a little bit of yoga, and the importance of legitimacy. We will remember that. We will now go to Justice Ricardo Lorenzetti.
Thank you very much. I would like to say that we are all seeing a lot of international agreements, laws, declaration of politicians and parliaments all over the world. But when the judges apply those laws, we are attacked because there are a lot of criticism about this kind of activism. We are not activists. We are only applying the law. But it put a question of legitimacy and judicial independence, because as I can see all over the world and in a lot of countries, we are assisting in a scenario of institutional stress, because independence of the judiciary, when we apply those kind of laws, and it implies that there are economic consequences or some limits of the power of other branch of powers, it creates a lot of conflicts. This is why we need to work together. We need to participate in the the Global Judicial Institute on the Environment to share not only our experiences, but also solidarity between judges and prosecutors all over the world. I think it's a very important time, but it's a challenge time. Thank you.
Thank you very much. I think the whole issue of the role of the judiciary working with the other arms of government and the importance of solidarity given the kinds of issues that come to judges because of what they decide. And I think Justice Ricardo has raised this whole issue of activism and the judges will be attacked for activism. And I think in solidarity, then people can discuss, the judges can discuss what they need to do. We will now go to Justice Dambuza.
Look, I think it is a tricky context to navigate. The balance between overzealousness and doing enough to do justice to the cause that serves before you. But I think part of what makes things, the context a little murky is that when we are confronted with the law that I think most of us did not do, let me speak for myself. I did not do environmental law at school at that time, 30 years ago at university, because it was a distant elective that I did not consider immediately necessary. And so when I am confronted with a complex environmental case, I sometimes, or some of us think, we need to there is much more that we need to do than we can, in other words, than we are equipped to do. We do have legal principles that are already in place that we've been using for decades. The other day I mentioned, as we were discussing the incident of being confronted with parties that have not referred to a specific legal principle or a constitutional concept that you as a judge know is relevant to the dispute before you. And I think the discussion we had went along the lines, well, you can apply it in the manner that you perceive it and in the manner that you think it applies to the facts. But we tend to forget that when we are faced with the same difficulty in an ordinary civil case, we call the parties in and say, talk about this principle, because before we want to get all the answers from ourselves. So we are sitting with some of the instruments that assist us, the legal principles. So that's where we start, but we also do need to realize that we are confronted with a different context, and to study that context is very important as well.
Thank you, Judge Dambuza. Justice Fabienne.
Thank you very much. I would like to say three things very quickly. I think, again, legitimacy for me is very important. I remember that in France we have what we call the Yellow Jacket Revolt. I don't know if you have heard. And it was about measures taken for, at least presented for environmental measures. So I think that we should be aware that it could be a temptation for the governments to transfer to the judge a responsibility of unpopular measures. And I think that we should be courageous, we should be imaginative, but we should always stick to the law. I mean, the law, all the law, nothing but the law. But the law, including the international law, including the new tools that international law gives to us, but always stick to the law. The second thing, very quickly, I totally share what Ricardo said in his previous intervention about the importance of implementation. I think implementation is key, and implementation is about implementing the law, the commitment the government has accepted to take, etc. And the third thing I would like to stress is the importance of exchanges between the judges from all the different nations, all the different continents, exchanges, documents, experience, to create networks, to exchange on case law, etc. Because I think that climate change, in particular, and environment in general, is a very special issue because it's an issue that concerns all the judges, in spite of the differences between our national legal system, which is, I think, rather unique, in fact. So I think that the kind of moments that we have are absolutely key because it's easier to be courageous, to be imaginative when you have the possibility to confront and to exchange with other judges that have the same problem as you. Thank you.
Thank you very much, Fabienne. Justice Sapanambala.
Yeah, thank you. I'm just looking at Justice Michael from Hawaii. Whenever we were just discussing during lunch break, he talks about sea level rise, and I was talking about how glacier is melting in Himalayas. And then he asked me how fast it is melting, the Everest is melting. I said, we have no tool to measure it. So what I want to say here, to protect the nature, we need to connect with the science.
Exactly.
Second issue is like, we talk about access to justice, but the challenge Asia-Pacific region is facing, especially when there is a transnational nature of environmental harm. We don't have neither we have a law nor we have a mechanism. So how to strengthen the mechanism, how to expand the law is one of the challenges, and therefore we need to continue our conversation to make sure that we have a justiciable system to protect the nature. Thank you.
Thank you very much. Justice Said Mansoor.
Stand up again. Okay. You see, I think we have a lot of room within our jurisdiction, you see. The lane is pretty big, to my mind. And I think we need to be creative. It's the ingenuity. It's that innovation that's required. Who would have thought that Article 9 of our Constitution, which says right to life, we would go ahead and carve right to pollution, right to an unpolluted world, right to a clean air within the right to life. And who would have thought the right to dignity under our Constitution would mean right to dignity of nature? So these are innovations. There's a lot of space. Nobody's saying step out of the jurisdiction. But within the space that we have, there is creativity that's required. And that is the need of the hour. It's not a litigation which is just a litigation between A and B. These are serious issues. The planet is in trouble. So I think this is time the judges need to stand up and do something about it and be creative. And nobody's saying get out of the jurisdiction. Another important point is that the very construct of judiciary is it's different. We are neutral by design. We don't have any vested interests. We do not have any political considerations. So we're ideally suited for the time to promote all these ideas that we talk about. So I think it's high time that you should spend time on creativity, innovation, ingenuity, and try to expand human rights, or more importantly, rights of nature, because it's all about nature. Thank you.
Thank you very much. Thank you very, very much. We'll now have, you can sit, so we have the others will talk where you sit, where you can sit. Justice Fabian, you didn't need to leave. Yeah.
You're not usually asked to leave, you see. I'm not really used to that, but whatever you say.
Feel comfortable, Justice.
Yeah.
We have less than 10 minutes before we're thrown out of the room. So we'll go quickly to the earlier justices to give us their 1-minute message. And let where you are, but we request you to face that side so that the camera, but yes.
Okay.
And then I saw a few hands, so probably.
I will take only a minute to exercise my right to complain. Not complain about the hours, like my colleague from New Zealand is absolutely right, but to complain about something that we are feeling. Since the pandemic, 80 countries, 80, the quality of democracy has declined in 80 countries. We felt that we are being pressured and pressured. Judicial independence in many countries is only a concept. It's not on real ground. And as president of the International Association of Judges, I am very pessimistic about the future of rule of law and democracy if we all stay silent. We in this room have a role to fulfill. And I have no doubt that without judicial independence, without democracy, without rule of law, it will be impossible to defend environmental law. Because those who are powerful, those who have the economic power, the political power, normally they are not very keen with the environmental law. And we all know that. And that's the message, the complaint I want to bring it to. Thank you.
A genuine complaint. Nick, less than a minute. I see 2 hands, even with a standing up.
Well, I think the message I take away from this is that everyone in this room who is not a judge, and I'm not a judge, has an obligation to go back home and work with all of our families, our communities, our local authorities, our legislators who don't fund the courts very well with their budgets. We need to pour much more money into funding the administration of justice. And if we're going to get democracy, we have to say we want courts to be well funded and do their job. Thank you.
Hello.
Yes, Your Excellency.
Hello, I'm audible. I'm
1 minute.
Virendra Rawat. I just wanted to know that about the responsible judiciary when the element of environment must be addressed in every order the judge passing on or small or big issues, national or international issues. How to judge the impact of the judiciary on the environment?
Yes.
Hello, I'm Professor Amélie Gaillard from the Normandy Chair for Peace. I would like to emphasize that the fact that we are dealing with existential threats, and in the French Constitution we have fundamental duties and rights, and you have all the tools already in France to promote rights for future generations, environmental obligation, duty to protect the future. You have the all the provisions already. By interpretation, this is possible.
Thank you.
Thank you. Brilliant presentations.
I hope Judge will also respond to that question.
Okay.
Sorry for that.
I'm not too sure about that, but I'll join in my dear friend Justice Michael Wilson from Hawaii. We are sinking. We have an emergency. Ordinarily, when emergency strikes a nation, certain rights, certain laws get suspended. Do we have any insight into addressing this emergency? I leave the question to the delegates, the panelists.
Thomas?
Thank you. Thank you very much. Obviously, I'm not a justice. Maybe that was a dream, but my life went a different way. But I just want to say, I guess maybe echoing a number of the excellent points that have been made here, that a lot of this is about judicial capacity. And I think the reality is a lot of the people on the stage here are very lucky in the sense, challenges though they be that exist, there are resources of a sort. There are many countries, particularly in the Asia-Pacific region, where either for lack of financial resources or, frankly, because of the immense political and other pressures that the judges may be under, and from a sense of isolation, they're not able to rise to that challenge. That's why, from our perspective, I think one of the important things is to provide the capacity building, to provide the resources, financial, but also intellectual knowledge base, so that they can be aware of all of these innovations that you're rightly speaking about. And I guess my second point would just be, it's so important that we use the innovative tools, including, provisions in the French Constitution. Unfortunately, there are a lot of countries that don't have a progressive constitution like the French. And so at some point, it's going to be necessary, when the judges exhaust all of those tools and they've interpreted laws and constitutions and international treaties as expansively as they can, there's still going to be a need for more law, because the judges can't do it all. And I think someone made the comment about how, politicians might, want to make the judges take the unpopular. I think that's a very real concern. And I think we can't let them do that. We have to make those who are accountable to voters realize that they need to do the right thing. And that's why I think it's about capacity building for legislators and members of the executive, as well as judges. We're all in this together. It's an all-of-government approach that needs to be taken. Thank you.
Thank you very much. And that's why institutions that, like Global Judicial Institute, the United Nations Environment Program, and African Development Bank will continue to support judges in that enhancing the capacity. One last speaker, yes?
Thank you so much. Maya Groff from the Climate Governance Commission. I'm an international lawyer based in The Hague. And I've had the privilege of working with judges from all regions of the world in developing new international treaties and applying these treaties. And I found the judges some of the most effective, international law makers and helping with the operation of these treaties. So my question to you and your colleagues is the issue of a new layer of strengthened international jurisdiction to address our global environmental law and the obligations which are there for states, other actors, and whether you know of colleagues that are championing this idea, either for an international court for the environment, what this might look like, or strengthening the ICJ, for example. I'm working right now with U.S. federal judge Mark Wolf on a new international anti-corruption court, which now has acceptance and support from Canada and Netherlands, among other countries. And so I'm just very interested in this idea, and also because I know judges can be such effective advocates at the international level. Thank you.
Thank you very much. If you promise to respond in less than a minute, Justicia. No, to respond.
I thought I just quickly say, yes, the thought has crossed, this has come up for discussion earlier, responding to your question. This thought has been, discussed, even though this is a matter of an international design of which we judges can't be a part of because it requires legislation. But yes, this discussion has taken place, and yes, to have an international court relating to environment, that will be something akin to ICJ, which could look into global kind of disputes. Yes, the thought is there. I don't know where it'll go, because we judges can't really make it happen in that sense. It's the policymakers.
Just to say, in this issue, of course, it would be ideal, but the problem is the emergency that we all said. And in the meantime, I think that national judges should appropriate international law and especially Paris Agreement, etc.
Thank you very much, all the panelists. I think the discussion was lively. We have had different perspectives from each speaker, and I hope each one of us leaves here with a specific message from them. Thank you very much. Thank you for your participation.